law rules of the Supreme Court and Court of Appeals, 5-2C, opinions, precedential value. Every Supreme Court and Court of Appeals opinion issued after July 1st, 2009 is precedent and may be relied upon and cited by any party in any proceeding. Hello, and welcome to Unpublished Opinions, a short circuit podcast. This is the show where Institute for Justice attorneys talk about things other than the federal courts of appeals in a rather relaxed and unscripted atmosphere. So if you are looking for good old short circuit content and discussions of the federal courts of appeals, don't worry, that's coming up later this week. As it does every week, we are not diminishing the content of Short Circuit for this podcast. So if you don't like this show, that's fine. Just hit pause and then go elsewhere on your feed. But if you would like to hear what are on our minds about other things in the law, then we'd love for you to stay with us. Joining me today to do those things are Diana Simpson and Josh Windham, both IJ attorneys. Welcome to both of you.
Thanks, Anthony.
Thanks for having me.
So we discussed in a little bit of planning for this show what is on everyone's minds, and the topic of legal fiction seemed to be up there. Legal fiction has different meanings to different people, I've learned. So, Diana, what kind of legal fiction are you talking about?
So when I use the phrase legal fiction, I'm not using I know there's a debate about whether Ex parte Young is actually a legal fiction that you can't sue the state. Is that a legal fiction? Is it not? I'm not that serious about it. When I'm using the phrase, I'm saying what courts lie about.
Ouch.
And one of them is that, we have this virtual unflagging obligation of the federal courts to exercise the jurisdiction given them. That's great language. It's soaring. Oh, yes, courts always go through and exercise jurisdiction. And it's a hot pile of garbage because there are so many forms of abstention. You can get kicked on, let's see, I have the list. It's Pullman abstention, Younger abstention, Burford abstention, Thibodeau abstention, Colorado River abstention, ecclesiastical abstention. I haven't run into that one yet in my own work. You have Rooker-Feldman doctrine. You have sovereign immunity. You've got all kinds of problems and circumstances where the federal courts are saying, despite the fact that Article 3 vests jurisdiction in us to hear causes of action, we're not going to because we have this other reason.
Well, can I interject that? Doesn't that sort of beg the question, Diana? Like, isn't the point that those courts are making that they actually don't have an obligation in that context to exercise jurisdiction because it's improper?
Well, but they've made it up, right? So, younger abstention is like the example that really just frosts me, because younger abstention is a circumstance where the federal courts said, okay, we're not going to get involved when there's this underlying criminal proceeding. And so whatever the propriety of the original case involving younger abstention is, and I think a good argument can be made that you don't want a federal proceeding going on at the same time this jury trial is going on. I think there's also good reasons the other way, but whatever. But whatever kind of the original reason was, it's now been expanded. And so now it's not just criminal cases, it's also civil proceedings. And once the state court even thinks about doing something, or the state administrative proceeding even thinks about doing something, all of a sudden federal court is completely closed off, despite your having a legitimate hook to get into federal court. It drives me bananas.
If I give maybe a little bit of context here for people who aren't lawyers, who haven't litigated this. So you're talking about where you're in court, you file your lawsuit, and the court has jurisdiction. That is, it's not like you're suing about something that federal courts just don't even look at. But then there's this other reason, even though we could hear your case for prudential reasons, we're not going to. And that usually has to do with some kind of thing going on with state government that the federal court's like, well, we're part of the federal government and we just don't think we should get involved here.
Exactly. And so younger abstention is not a jurisdictional bar. Like there are some things that are jurisdictional bars, right? Like you need to have adverse parties. Like
A federal
that's
claim. Often.
Exactly. But younger abstention, it's just morphed into this enormous blob that gets in the way. And you can file your federal case that's legitimate and there's no block to it. And then the states can later get involved, and still the federal courts will sometimes say, oh, there's younger abstention. We're not going to get involved, even if you filed first.
Well, one of you said it's not a jurisdictional bar, but wouldn't it be the subject of a 12b1 motion? Like, doesn't that get to the court's subject matter jurisdiction?
But it's not a jurisdictional. It's a prudential concern, I think.
Yeah, but the courts rely on that prudential concern to say they don't have jurisdiction over the matter, right?
But it's made up.
It's fiction.
That's right. Yeah. So I agree. I mean, I think all these doctrines are largely silly, and they prevent meritorious cases from getting adjudicated. But one thing I wonder, Diana, is where that quote unquote virtually unflagging obligation comes from. Is it the court's duty by virtue of Article 3? Is that how you read it?
I mean, it's really the statute, right? Because Article 3 says you can limit the jurisdiction, which Congress does all the time.
Mm-hmm.
And so, with matter in controversy or whatever. So really does the statute say you can be in court? And of course, what Diana's talking about, the statute does say you can be in court.
Right. Like if you just bring a regular Section 1983 action, you're not even an issue with like sovereign immunity. You bring an appropriate 1983 action against an individual or a municipality or whatever, and you've checked all of the jurisdictional boxes. You're in court under a federal cause of action. You filed. You've done all of that, and they're saying, well, we're not going to hear it because of this other reason. That
do you think there are any legitimate prudential concerns that courts could bring to bear on deciding whether to exercise jurisdiction?
I mean, I'm not saying that it's always illegitimate. It's frustrating to see this, it's frustrating to see the soaring language in all these cases where they say, oh, we have this virtual unflagging obligation. We always hear these cases. It's really important. And then just get kicked in the face over and over and over again on abstention.
So we did a little show on younger abstention a couple years ago now. And one thing that was discussed is like there are kind of, you could see limits on where using Section 1983 to get involved in ongoing state proceedings might be weird. Like, say you're in state court and there's a ruling on your evidence motion, and that ruling is a criminal case, and that evidence motion is you think is a violation of one of the provisions of the Bill of Rights. Say it's something in the confrontation clause, maybe Sixth Amendment. And so normally what you would do there is you make your objection and then later you appeal it. And, that's your remedy for that constitutional violation. Well, could you just go to federal court and get an injunction to tell the state judge, about even appealing during the trial to change its mind on your motion and grant it, or not grant it, or whatever it is? Or is that, that does sound kind of ludicrous. So, but it's within the court's jurisdiction, right? So what about that?
Would there be a ripeness concern with that? Like, so for example, obviously the constitutional injury in fact has occurred if you think of the violation itself as just sort of a per se injury, but suppose it sort of has no effect on the outcome of the proceeding, right? Like the federal court might want to wait.
Well, what if it is? What if it's like that you're going to put on a witness who's going to finger your client, or not, or not finger, whatever it is? I haven't thought through the hypothetical, and so it's super important. But the trial judge has said, nope, motion denied. I mean, normally you'd appeal that, but you have jurisdiction in federal court. So where's the line? Where's the line, Diana?
I'm not saying there necessarily is one. It's just like younger abstention has exceptions, right? So you're talking about an exception to federal jurisdiction. And, we're going to have inception exceptions soon.
Well, say you wipe all those darn doctrines away, those fictions, Well, maybe here's one that you still is going to happen. Or even if it doesn't happen, federal courts are going to be like, what? Well, they're going to say one of two things. They're going to say, what wrath hath Congress done to us by enacting the statute that allows us to do this crazy thing? Or they're going to say, Congress couldn't really have meant this. And they'll
But
start
they
making
did. I mean,
exceptions.
look at 1983. The whole purpose of 1983 was this recognition that state courts were pretty awful and that states were exerting just really terrible powers and just it's incomprehensible how bad the Jim Crow era was. And so Congress said, okay, all right, great. Here's a way for you to get into federal court, and then for the federal courts to be like, well, actually, why don't you just resolve that in state court first? That's the whole point.
Well, you put it that way.
I'm sorry, I get a little worked up.
Put it that way, it sounds like, my little hypothetical, maybe Congress, the remedy is, or the solution is Congress would change the law.
Congress doing something.
Do you want to?
Anthony.
Actually, this is a great segue into my legal fiction.
Okay.
Which I'm not sure if, I'm not sure I fully intellectually grasp the type of fiction we're talking about here, but let me get at one that I run into in my cases, and I'm sure Diana has too, and Anthony has as well. Just the idea that the legislature, one, acts in good faith all the time, two, always considers, facts relevant to the law it's considering enacting, tries to exercise its duty to abide by the Constitution when it's passing laws. In other words, the fiction that the legislature is doing its job, and that we have to sort of presume that at the outset. I mean, that's sort of question begging, right? Like, isn't the whole point of judicial review to look at what the legislature has done and say whether it complies with some external source of law, whether the Constitution or precedent or a broader statutory scheme or whatever, right? It just feels to me like courts indulging in that kind of presumption. I mean, the justification you often hear for this is, oh, well, it's a way of executing the separation of powers and honoring that for courts to give deference to the legislature and assume that they're doing their job properly. How is that the separation of powers? Isn't the court's job just to look at what's happening and say what the law is?
Well, this is like
Yes.
a little obvious. This is, you're basically identifying why the Center for Judicial Engagement exists. So
I was pumping you up, actually.
I'm not going to violently disagree with you. Maybe Diana will.
Let me ask you a question, Anthony. Have there ever been situations, either as CJE director or even just thinking about this issue, where you've thought, man, deference is really appropriate here, or a presumption of good faith, or considering all the relevant evidence, or whatever presumption you want to say courts give legislatures depending on the context? Have you ever thought that's a fair thing?
Well, I will say, that, so not in the context you're talking about. I don't know about deference to the legislature interpreting the Constitution, whatever Constitution you're talking about. But I will say, I don't think it's inherently wrong to have, say, presumptions. You're going to have presumptions in all kinds of fields in the law. I mean, you have the presumption that the plaintiff needs to meet their evidentiary burden, right? That's just the very basic example. And so you can have presumptions where you're, trying to interpret very complicated statutes. One example where you might have presumptions about the legislature was trying to do this, or the legislature was trying to do that. So I don't think there's anything inherently wrong about presumptions. I don't like the presumption of constitutionality, of course. I think a court should be looking at a statute when it's questioning whether it's unconstitutional and not deferring and not thinking, well, the legislature, of course, we're going to defer the legislature was doing something that's that it thinks is in the best interest is constitutional, because that's kind of the fox guarding the henhouse fallacy. But yeah, if it does a little of that, I don't think that's like that big a deal. What's a big deal is the almost irrebuttable presumptions that we have in so many fields of law. And
Yeah.
so the problem isn't because you really can't have a legal system, our common law legal system, along with looking at, statutes and regulations or whatever, that has some kinds of presumptions, because that's how the courts work. Courts are going to inherently do that because it's a way for judges to do things, and that's fine. It's the irrebuttability of some of those presumptions that's the big problem.
Yeah, I mean,
Well, right.
Go ahead, Diana.
Well, so with Chevron, on the chopping block with both Laufer and in the other case that they're considering at the same time, I think a lot of these questions were presented there. It started out about like greenhouse gases and all of these big issues that like judges don't really know anything about, and so perhaps administrators or who are steeped in this information can make better decisions, and then judges say, okay, well, you guys know what you're talking about. I'm a simple country lawyer. I don't. So I'll give you the benefit of the doubt and kind of let you go with it. But then that's morphed, because once you give anybody any power, they just kind of continue to grab and grab and grab. And so now you've got, as in Laufer, you've got these, government officials that have to be on fishing boats and like the fishing boat companies are bearing the costs and they can't afford to. And so it's just gotten to such a point that it's indefensible. And so Chevron is likely, in my view, kind of going away. But how much is it going to go away? I don't think we're going to be in a world where the judiciary is constantly reviewing everything from kind of first principles with fresh eyes and saying, well, I'm not going to give anyone the benefit of the doubt here. Each of you has to prove your case.
I think Chevron is an example of something that could have been just a mild presumption, which is the old Skidmore deference. That's the other kind of deference. That's not much a deference, but it's at least it's a starting point. That it's morphed into this. It's not Chevron isn't irrebuttable, but if you take it strongly, and a lot of lower courts have, then it gets pretty hard to do. And then you also have this problem about kind of on top of that, which is actually even different than in the constitutional context. You have the problem of the judiciary, word I still can't say, deferring to the executive branch on interpreting what Congress says, which you actually don't. It's even worse problem than it may be in some of the constitutional contexts.
So one of the things that is kind of striking me right now is that there could be a difference between presumptions and deference, right? Like, presumptions kind of get at the adversarial system and who should, like, whether the plaintiff bears the burden, as they often should, right? In the criminal context, the prosecution bears the burden. So that makes sense to me, given the way our adversarial system is structured. But the idea of deference seems sort of like logically distinct from that. It's the idea that, setting aside whoever has the burden of proof, the court should still load the dice one way or the other, or stack the deck one way or the other. And that seems sort of like independently wrong. I could see a world in which you might say a plaintiff bears the burden of proof when trying to establish the unconstitutionality of a law, because they are the plaintiff. That doesn't require the court to nevertheless engage in deference towards the law, right? And kind of an example, you might think of, like, imagine Congress passes a statute that just sort of says, like, Anthony Sanders can never talk. I mean, that seems like an obvious violation of the First Amendment, and the burden of proof on the plaintiff is going to be pretty easy to meet in that context, right? All you got to really do is point to the law existing.
Yeah, there's technically a burden, but then you get the court and you get over it pretty quick.
Yeah, but you could imagine a world in which the court isn't applying any kind of deference towards the statute or Congress or whatever, but the plaintiff comes in and says, look, this economic statute is unconstitutional because it violates equal protection or whatever. And, like, the plaintiff's got to make a showing in order to prove that, right? The court isn't under an obligation to do the research for the plaintiff, to build a record for the plaintiff, and that sort of thing. So that's kind of how I see it.
And the criminal courts certainly handle that quite well, right? The defendant has the presumption of innocence, and all, the government has to meet its burden, to prove that the defendant is responsible for the crime, guilty beyond a reasonable doubt. But they're certainly able to do that in that context without giving, without saying like, okay, well, the government is right, probably. So go ahead.
Yeah, I mean, that's the ultimate, beyond a reasonable doubt, that's the ultimate burden that we all accept and think is great. But it's a hard burden to meet. And so it's not like hard burdens to meet are inherently wrong. It's just if it's set, I mean, part of it is it's set up for a certain purpose. And so the deference to the legislature is set up for a certain purpose. And really what
it's like, which side of the scale are you going to put your thumb on? And if the thumb is on the side of liberty, which it is in criminal cases, why can't it be on the side of liberty in civil cases
because
too?
the reason why that not the
will of the people, Diana. That's why.
Will the people is the really silly way, because we all know the legislature is not actually the will of the people. And if anyone disagrees, they can go read what we've all written at various points about that. But really, it's the thumb on the scale of democracy is where that comes from. The more understandable reason, right? So you've set up this legislature, this Congress, and they pass laws, and that's how the system's supposed to work. And so we should defer to them about, how this legislation is going to work. And you just come on in here and say, oh, actually it violates this Constitution thing that, we adopted a long time ago and most people have forgotten about. And I think that's just the inherent tension in having a written constitutional system that, a lot of people aren't comfortable with.
I know that we probably want to move on from this topic, but just kind of one other thing that strikes me now that maybe you guys have thoughts on. I mean, what would you think of a system where the legislature, how in the criminal context, there's actually a burden of proof that's, codified, right? So what would you think of a situation where the legislature says, like, you've got to meet this burden of proof to prove a statute is unconstitutional? Can the legislature even do that? Or is that itself unconstitutional? Does it violate, a judicial duty? Does it... Because there are some systems, for example, where I think it's like in Montana, you've got to convince a supermajority of the court that a statute is unconstitutional. Oh, is that right?
No, but that's in the state constitution.
Oh, okay.
Yeah. I mean, it's like with with the recent vintage of laws where they are jurisdiction stripping and saying like you either can't sue or you can only sue in one court in the entire country. That seems perhaps risky, constitutionally risky, and I actually haven't thought through all of the consequences of that, but given that the legislature gives courts jurisdiction, that seems perhaps less offensive than saying, the supermajority required to find a law unconstitutional, at least if that were passed by statute rather than in the state constitution.
Well, another legal fiction, maybe it's a legal fiction that we were talking about is stare decisis, whether it's real. And someone had thoughts about that?
Yeah, I do have thoughts about that. So stare decisis, it never genuinely feels.
And please tell us what
me.
stare decisis is, and maybe that's the point of our whole conversation. But
right, I started talking about younger abstention without actually talking about it. Stare decisis is basically when the Supreme Court says, well, we've already decided this, so we're not going to decide this again, or we're not going to overturn that law. It's this presumption, if you will, that what we said before was correct and that we don't want to revisit it unless it's particularly important. And as we can tell from recent history, the Supreme Court doesn't always do that. And I don't think they should. If the court was wrong when it issued a decision, and that decision is still wrong today, it should right the error. Like, I don't think that's... I don't think we should just accept, well, we already said it, so even if we were wrong, I guess we're just going to continue being wrong. And the frustrating thing with stare decisis, it's now this like 5-factor test, and they pass it when they want to pass it, and they fail it when they don't want to pass it, right? Like, to me, it's just... I'm not saying stare decisis doesn't make sense. I think there are applications in which it is particularly important, like contract interpretation and other things where people like actually change their business models based on what the state of the law is. But with constitutional interpretation, for example, just because something was said once doesn't mean that that's the end of it. And it's just, it never feels like a principled test to me. It always just feels very outcome driven. And if I don't like the underlying decision, I think I'll take it. And I think the Supreme Court has made this like even less necessary, this stare decisis test, because they just don't have to grant review if they don't want to. Like if there's a case saying, please overturn the slaughterhouse cases, for example, the Supreme Court hasn't yet accepted review on that question presented. And so they don't have to, because they don't have to engage in the stare decisis test anyway. And so if a decision is wrong, fix it.
I mean, what's also kind of funny, at least in the constitutional context, is that the stare decisis factors, and I'll just list a few of them, right? So quality of reasoning, reliance on the decision. What are some others, Diana?
Aren't they kind of the same thing over and over again?
Even though I just briefed this, because my brain is going totally dead right now.
What else is it? It's
quality of reasoning, reliance on the decision. One of them is whether it's part of a body of jurisprudence, recency of the decision.
The nature of the error.
Uh-huh.
Yeah, what does that mean?
The workability of the rules.
Thank you. That's the one I had in mind. Okay, so the point I was going to make about the workability, quality of reasoning, and reliance is that they all, in the constitutional context, they all collapse into the same question, which is, was it right or wrong, right? Because if it's wrong, the quality of reasoning was poor. If it's wrong, that means there's no workability because it's not workable to perpetually violate the Constitution, and there's no valid reliance interest in violating the Constitution forevermore.
Right.
And so, is this really just sort of like a performance that we're doing? I mean, I think probably the value of stare decisis comes more into play when we're talking about, marginal cases where of statutory interpretation where it's not obvious what the answer should be, and the court has to sort of fill in the gap and figure out what this unclear statute means. And it's not going to go back and revisit that if 50 years of people have built lives and businesses and whatever else around the court's interpretation of that statute that Congress could easily change, right? Or at least that's the fiction. And but that's not true in the constitutional context. People can't just easily change the Constitution. Again, a fiction. And so that's what the court says in the constitutional context.
And I think a lot of what they're playing at is, or at least some of what they're playing at is institutional legitimacy, right? They don't necessarily want to be seen as things are going to change dramatically every time there's a change in control of the court, for example. And so, we said X, but 15 years from now, when we are now the minority, it's shifted to Y. And so the court is, I think, trying to avoid that. But it just doesn't feel real to me, because if it's wrong, it's wrong. Plessy v. Ferguson was wrong the day it was decided, and it was wrong every day that it continued to exist until it was overturned in Brown.
Yeah, and I would agree. I actually don't think there's a really good reason to worry about the change in the composition of the court affecting the outcome being somehow a sign the court is illegitimate. I mean, judges are humans, and they judge with frameworks, and different judges have different frameworks, and that is inherent in the court system.
Well, some of that, right, is that there's not agreement either in the legal culture or on the court as to what the basis of the law is. So if you're like a hardcore originalist, you're going to look at stare decisis very differently than if you're a living constitutionalist or a common law constitutionalist. I know is one flavor, and then there's others in between. And so if you're thinking, well, what are the reasons that we would depart from precedent, you're getting very different answers. And I think that's why you have these multi-factor tests that collapse into each other, because it really is like a rule by committee, because not everyone could agree on what the rules should be. And so they just kind of throw it up there.
Right. We can't pretend to care about judicial confirmation hearings, right, if we also think that changing composition of the court would affect its legitimacy. We all agree that we have preferences about who's on these courts, right? And for good reasons. We should have preferences.
I think it's also, it's hard. I think it's you need to think about it differently when it's the Supreme Court or when it's state courts, because when you're in a state court, stare decisis often is you're talking about the common law, and common law stare decisis is a very different kettle of fish than stare decisis about a statute or about a constitution, because there the case is the law, right? There ideally cases in the common law are actually reflective of like a larger like law, and so they aren't actually the law, but these days they're treated as essentially the law. And so,
is that your favorite legal fiction, Anthony?
What's that?
Is that your favorite legal fiction?
That's a good legal fiction, but that's a whole different conversation that we could have sometime. So if there's like a rule of personal liability and the court is thinking of changing it, that's I think in some ways that's like harder. That's a harder sell than like, well, we were wrong. Well, why were you wrong? Well, because we were wrong about the law. Well, that's fine. But if you think that that case itself is the law, then you need something more than that. And I don't, God knows what that might be. Just like we think society is going to be better off if then you really are acting as a legislature, as a court. And so anyway, so if you're a state Supreme Court, you're thinking of stare decisis that way, but also constitutionally. Whereas if you're the U.S. Supreme Court, with very few exceptions, like their admiralty jurisdiction, you have the luxury of it being this other kind of stare decisis. And I don't know if they'd be better off or worse off if they had to also worry about like federal common law more, like they did in the old days, but maybe that would sharpen their thinking. I don't know. Maybe it wouldn't. Maybe it would just be another problem for them to deal with. And what I just brought up kind of goes to a point Josh had about old cases and new cases, or old wine and new bottles, or what do you do with the bottles? So I was a little bit confused, but I think you're on to something.
Okay. I'm also confused.
Uh-oh.
So that's where this question comes from, actually. Please help me. So I guess the context, to be transparent about it, is that I recently have been mired in briefing in 2 state Supreme Courts about what their state constitutions mean. And one thing I've found interesting is that the issues I'm briefing, by and large, have been extremely under-litigated. And so what you have are, a couple recent decisions here and there that seem like they touch on the clause we're invoking, but then some like super, super old decisions from right after the clauses were adopted, near the founding, that also speak to the provisions. And so one question you might have is, let's suppose, for the sake of this discussion, that we're just talking about 2 cases, right? One just after the founding and one announced like 10 years ago, right? So relatively recent. And they both take conflicting perspectives on what the relevant clause means. Which one is, more persuasive or authoritative? I mean, we're taught in law school this sort of hierarchy of authority, right? It's like, first you go to the jurisdiction and it's like, what's the highest court? And then what's the most recent decision from that court that's on point? And then you kind of work backwards from there, right? And you go out and out and out for persuasive authority. But like, why is the more recent decision binding or more persuasive? It kind of gets at some of the stuff we were just talking about with stare decisis. But, you might think that a court, especially a court populated by, possibly members of the convention that adopted the provision, would have a much better sense of what that provision was designed to do than a court 150 years later, right? So I'm just sort of wondering why it is that we should prioritize more recent precedent over older cases, especially if the more recent one doesn't even address the older one, right? There's no overruling; it's just sort of silent on that question. It's just a kind of authority question that I don't have a strong opinion on, but I've been wrestling with recently in some of the cases I've been briefing, so I just thought I'd bring it up.
I mean, some of it is certainly like what your perspective is, right? Like, are you an originalist or are you a living constitutionalist, or whatever kind of in between, as Anthony was just mentioning? Um, and so I think in some ways there are some people who don't particularly care what the old court said, like what the new court said, or what the most recent version of it is just how it's currently being interpreted. And if you want to change how it's currently being interpreted, you have to have a good reason. And what is your good reason for that? Whereas I think with originalism, what you're trying to do is say what it meant when it was passed. And so then, of course, the old cases matter, because then you're talking about people who are close in time and perhaps, as you said, were part of the convention, can talk about it in a way that lends credence to the theory. And so, I don't know that like new cases are like the best ones. I guess what my perspective is that you have to, if you're saying that the new cases aren't correct, you're going to need to explain why they're incorrect. And does the court need to overrule them? Or can the court just say, whatever these cases say, the provision at issue actually means X.
Right. I mean, Justice Thomas does a lot of this, a lot of citing to super, super old cases in, 2024, even when there's a lot of more recent precedent directly on point that will answer the question. He'll just cite the 1821 decision or whatever from, the Wheat Reporter. I just sort of, I agree with you that the relevant question ought to be, what is the law? What is the correct interpretation of this provision? I don't find a ton of appeal personally to this like appeal to authority where it's like, oh, the really old case had, justices who are part of the convention. That seems a little squishy and like it could lead down some weird rabbit holes. And so the perspective I have is just sort of, what is our best understanding of what the provision means, and then what cases have the most fidelity to that understanding. And people are going to disagree about that, but
yeah. I think the way that you explained it, Josh, that in this example, that the more recent case doesn't say anything about the old case.
Yeah, which is common, by the way.
Yeah, oh yeah, it is way more common than we realize. I think that is pretty interesting because it takes it away from just like, is originalism correct? Which, some of this debate just could be about, right? And the older case seems more, because of its timing, seems more, quote, originalist, and so you go with that. I mean, it could have been super wrong and like, against what people thought back then. It just happens to be those judges on the court. But putting that aside, when we're used to like the progression of law, and in say the constitutional context, and the newer case knows about these old cases and says, well, they're wrong, and then has a newer case, and then you have stare decisis with the newer case that you have to deal with, or what have you. And so we all know like lots of famous examples of this, and say First Amendment doctrine or Commerce Clause or whatever. But this is the more like normal thing where, especially in state courts, where you have a reading of the, say, state constitution at one time, and then 100 years later, you have another case, and those lawyers are busy and they haven't read all the case law. And maybe it was, before electronic databases even, or even with them, maybe they're not doing their job. And no one's done a law review article about it. There's no scholarship on it. And so the court doesn't find this old case. And so they do a new thing without finding the old case. And maybe maybe flash forward another 50 years, and there's another case that doesn't know about either of those cases, and it does its own thing. So I think the question is, what does a court do when some super competent lawyer actually finds those cases and brings them to the court's attention, like it sounds like you have done? And
I mean,
then
the reaction that, sorry, go ahead.
And then the court. So then the question is it really, was the second case really overruling, so to speak, the old case? I don't think it was. I think there's just two cases. One is closer in time. So there's a presumption for the newer case, all stare decisis, originalism, but putting all that stuff aside. But it doesn't seem like the court has decided the old case was wrong. The court just kind of on its own considered it another time. And then I think there's an argument there that's not originalist, not anti-stare decisis, just like, hey, you've done it two different ways. Maybe this one makes more sense. And so kind of you have to overturn the second case, but it's not really like super precedent, right?
I mean, so I'll give you a bit more meat to this question and just tell you the specific context that I had in mind. So North Carolina has an anti-monopoly clause. It's been sort of sparsely litigated. I mean, there's maybe like a dozen relevant cases in North Carolina's history since 1776 talking about this clause. More than that, but a dozen that seem relevant to the issue we're litigating. And largely these cases just don't talk about each other, right? So you've got a handful of cases from sort of the 19th century that we like. And then there's some cases after the New Deal that just sort of incorporate, rational basis review without any explanation whatsoever, and without referencing the old cases. And then there's some more recent cases that don't reference the rational basis cases and don't reference the original cases either, and just apply a different framework. And so it's like, what's the court doing? And I can't help but think that largely what's happening is just sort of, it's a product of the advocacy.
Yeah.
Right.
Yeah.
And the courts are busy and clerks are busy and they got the cases before them that the parties present, and then they got to issue a decision. And I guess, the perspective I have on what to do here is it's up to the litigants to force the issue. Right. So, maybe we should just sort of think, okay, the more recent precedent is what's controlling as a presumption, if you will. But if a litigant comes into court and says, look, you have these, ships passing in the night, all these cases don't talk about each other. It's super muddy. The court's got to decide, and the decision the court issues is dispositive in this case. Maybe that's like the way in which those issues get resolved, or at least we hope it is.
Maybe. I mean, I suspect that some of the issue is that courts have just changed over time, and judicial review has changed over time, right? Like you look at the early Supreme Court decisions and they're somewhat impenetrable. They have, paragraphs that like a single sentence takes up a full paragraph. And, you got these like per curiam decisions that are just very difficult to wade through. Whereas modern decisions are much easier to read. But then there's also this sense of humility, right? Like are justices today better equipped than justices in the 19th century at interpreting law? I don't think so. I think they're good in their own ways. And of course, it's much easier with databases today to find all of these old laws and all of these old cases. But are they better by virtue of being old? I don't necessarily think that's the case, but I also don't think that we should just ignore them. And so good for you, Josh, and like, getting all of those together and presenting them to the court. And I don't know kind of what the history of the North Carolina Supreme Court is. I haven't dove into it, but I wonder if that's part of it too, is that just the quality of the judiciary has changed over time, or maybe not the quality, but like the ability of the judiciary to go kind of in depth and spend a lot of time and resources outside of what the litigants present.
And this gets at what, Anthony, I assume you're going to transition to in a second, but I will plug something before you transition, which is a newer justice on the North Carolina Supreme Court named Justice Dietz, Dietz, wrote an article in 2022 while he was on the Court of Appeals called Factories of Generic Constitutionalism. And it's a fun law review article that talks about some of the provisions that we're raising in this case, including the anti-monopoly clause, and makes the point that I'm making here, which is that this seems super muddy and the courts haven't resolved it, and the court really should resolve it. So anyway, check it out.
Thank you for the tip. I was not just about the transition, because I had one other thought, is that I think this goes back again to what I was just talking about. So sorry for getting back on that hobby horse, but the difference between common law adjudication and constitutional adjudication is if you were talking about a bunch of cases and they all had to do with, say, forms of action or the interpretation of contracts or some rule of liability, that would be completely fine. Courts did this thing at one point about liability. Then they started doing this. They didn't even cite the old cases, but whatever. That's the law changed. And then they started doing this. And then later, the law changed and they started doing this. Like, for example, I learned this a few years ago, and it absolutely blew my mind that in if you look at like the late Middle Ages or early modern period in England, like maybe into the 1600s, I think, there was no action for for abridging a contract. So if someone like went back on a deal, there were all these legal fictions that they had come up with to try to do that. So it was like a tort, like you did wrong to me by not fulfilling the contract, and so therefore I sue you in some kind of weird trespass made up thing to try. And everyone knew that like what you're trying to do is enforce the contract. So they came up with this idea of breach of contract, and you could sue about breach of contract. It was a whole new civil action, and that's just how the common law works. And so to say, like, if I came in now and it said, hey, there's this old case from like 1600s where it's okay if I breach the contract, and they have to come make up this weird thing about how it was like morally wrong for me to not pay that money, and it's hard to do, and they don't have the right form anyway. I mean, it doesn't make any sense, right? Even if there's no legislation on the topic. But here, this is a constitution we're interpreting. Now, I will throw a little curveball, and that's that sometimes we adopt new constitutions. States adopt new constitutions, and then how does that? Are you adopting the cases that no one at the Constitutional Convention even knew about, but they were the relevant cases, interpreting that provision of the Constitution that is then readopted or maybe tweaked in the new Constitutional Convention? That could get really complicated real fast, if you want it to. But
yeah, I'd like the Illinois Constitution, for example, was last amended in 1970, which was
not amended. It was
whole
new thing. Was
I'm
adopted.
Sorry. Yeah, new Constitution. And so there is a provision that we're relying on in one of our cases that they basically copied it from the last one. But it's been interpreted over the time. So, like, do you use words as they were used in 1970 in interpreting that? Or do you use, like, the original words when the language was first inserted into the Constitution?
I would think, isn't the typical rule that you would use the original words if they're copied?
Well, that's what I'm arguing.
Okay.
This is a incredibly interesting topic we could do several shows about. Well, we won't today. But there is a super useful law review article on it that's hard, but it's because it's a hard issue, called Interconstitutionalism, that I will put a link in the show notes to for those interested. And actually a court that has done this a lot lately is the Georgia Supreme Court, because they've had so many darn constitutions. They've had like 11 in the state's history. The most recent one was only like 40 years ago. And so this comes up a lot for them. And they have kind of basically what you were just talking about, Diana, is a presumption that the last time they changed the words, whatever constitution that was, that is how you. And so quote, they're also originalists these days on the Georgia Supreme Court. So they say the quote original meaning at that time that carries forward through the next constitution, but it's only a presumption. So you could rebut the presumption if you could say language really changed and there's evidence constitutional convention, blah, 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 blah. So,
well, it was Montana, I think, that tried to use its adoption of a new amendment to eliminate the taint of Blaine and all of that, and they were not successful.
No, they were not, and that was IJ that did that.
Sure was.
So, speaking of state courts and federal courts, this is kind of like just protein idea I've had, but in talking, as I have a lot lately, about state constitutions protecting rights and state courts protecting rights, seems like, people often fall back on the idea of, okay, well, you have the federal constitution protecting some rights, and then you have the state constitution and state courts that kind of fill in the gaps, where either the federal courts didn't do their job, or the federal constitution just doesn't cover that. And often state courts will just kind of go along with what the federal courts do, and that's called the lockstep doctrine. And to some extent, so part of my pitch is state courts, do your job, think for yourselves, don't follow what the federal courts do. We talk about this at IJ all the time. And so sometimes we wonder, like we've been talking with, when I've been visiting law schools lately, talking with with students and professors, like, why are courts? Because a lot of people agree with me, I think, or in spirit, they agree with me. So a lot of us are like, why do state courts do that? Are they just lazy? So that's the easy way to do it. State courts are lazy. They look at what happened at the U.S. Supreme Court, and then they apply it to their own constitution, even if the language is totally different. I think to some extent, though, there's something where this really wasn't as big a thing until incorporation. And so for people don't know the whole history, the Bill of Rights being applied to the states. So First Amendment, right, freedom of speech, religion, and then all the criminal protections, cruel and unusual punishment, whatever. It was a long process, but it really didn't take hold until the 1960s for most of the Bill of Rights. A few of them only very recently, including work that IJ did in that regard. So the kind of like mindset of like using the federal courts is still evolving, I think, for state courts, even though it's been, 60 years at this point. I think it's not something state courts are reflexive on. They're still getting their sea legs, I guess, in this new world of incorporation, which of course wasn't a thing at all, way back at the founding of the country. And so that there's still some education to do that maybe is not unexpected, and we shouldn't be quite as angry at state judges as to doing the things that I think they should be doing.
Can I just ask a clarifying question? Maybe for the audience, maybe for myself. Why do you think that incorporation would be the reason that state courts would be delayed in interpreting their own constitutions?
So if you're interpreting, for example, your search and seizure clause for your state, it's written the same way as the Fourth Amendment. Before incorporation...
Not always, Anthony.
Not always exactly either. But say you're in a state where it is, or it's very close. And so seizure, unreasonable searches and seizures and warrants. And so before incorporation, state courts, they would look for guidance to the federal courts. They would look to guidance on other states that had similar clauses, but they knew at the end of the day, this is their thing. Then incorporation happens, and it's like, you don't even, like, you could just repeal the state constitution. You got the Fourth Amendment. You can raise it in state court. So we don't even have to worry about this thing. And then people do actually come in and raise these claims. I mean, IJ has had cases like this. Any competent criminal defense attorney in the country, and they raise the federal defense, and then they'll raise the state one and say, well, even if that doesn't work, the state one is a higher level of protection. And I think state courts it's kind of a different way of thinking about it. And maybe all state judges know this, but getting comfortable with what that new paradigm looks like, I think is still not been fully worked out with all the judges.
Well, can I just push back a little bit on the premise? I mean, I think I agree with everything you just said. But one thing that struck me when I just sort of in talking about this in advance of the show today and thinking through what I wanted to say, I mean, it just feels like constitutional law is still relatively nascent. And I say that, it sounds kind of bizarre because we've had a constitution, we've had state constitutions since the founding of the country and the states. But if you just think about all the constitutional issues out there, so many of them have been litigated and developed in the last 50 years or even 20 years. And it's sort of shocking, right? I mean, just think about the Second Amendment, think about the excessive fines clause, in the case IJ litigated, called Timms. The relevant kind of framework, the analytical framework there wasn't really established before the last few decades. And so it just sort of strikes me that constitutional law in general is actually in a relatively early stage. And part of the reason for that might just be that the government has gotten really, really big over the last century. And so there wasn't as much to challenge before the government was that big.
I think that's probably fair. I mean, criminal law, I think, has been pretty well developed for quite some time, and that's certainly a function of government enforcing its criminal code against its citizens. And so, that's going to just develop as those cases unfold. But, um, you know, on the other hand, perhaps there's a reason that the Third Amendment has been litigated twice in the last 100 years and doesn't seem to be headed for incorporation anytime soon, just because, there's not a circumstance, fingers crossed, not one currently and perhaps not one for some time, where the government is seeking to quarter troops in people's houses. Unless you can get creative like that. What was it? The Nevada case where they were doing the SWAT team in someone's house to get at their neighbor. That was interesting. In any event, but like you haven't needed to litigate all of the different aspects of the constitutions because they're not necessarily being abused, or people don't know about this particular protection. Whereas, everyone knows about the warrant requirement, and government is certainly not always following it.
I mean, what's interesting, Anthony, on the issue that you raised about state constitutional analysis being kind of in its infancy, I would agree with that. I mean, I mentioned that I've got a couple of cases for state Supreme Courts right now, and one of them is in the Pennsylvania Supreme Court, and we're asking the court to overrule a binding precedent from 2007 that we say is poorly reasoned and wrong for a number of reasons. But what's interesting about that case is that the court says in that 2007 decision is that prior to 1960, which is the point in time you're talking about, Anthony, there just isn't any relevant state constitutional law at all, is the court's position. Like, basically, state constitutional law begins in the 1960s.
Is that actually true? I mean, are there cases on this point before 1960?
There are, but they're very sparse.
Yeah.
Very sparse. And so there's some truth to what the court is saying, but I don't think that statement carries the weight the court, thought it did in terms of resolving the legal issue that we're asking it to resolve. But in any case, I think I agree with your point, Anthony, that we're in a very early stage of kind of state constitutional analysis. And one of the signs of that, by the way, is that, some state Supreme Courts have started to articulate like multi-factor tests for what to look at when you're interpreting your state constitution. So Pennsylvania has something called the Edmunds test from a case in the 1990s. And you look at, text, history, state cases from other states that are on, kind of on point analytically, and then state policy considerations. And then Washington State has something called the Gunwale test, which is 6 factors that are similar. And North Carolina last year in a case called Moore adopted sort of sort of reaffirmed a 3-part standard with some clarity that says we start with the plain meaning of the text, then we go to history, and then we go to on-point precedent from there. And so it's helpful for courts to adopt these multi-factor frameworks because it gives counsel and litigants a way of knowing how to brief them to get the courts to actually engage with their constitutions. But that's a recent trend.
But you're right. That is a recent trend in the last 30 plus years. But those tests, I would say, go back to what we were talking about earlier about legal fictions, because they're so malleable that the court can just do what it wants at the end of the day anyway, even if you briefed like all 7 points.
Yeah, and also the factors that courts adopt really depend on your judicial philosophy, like what you think the law is and what you think it means to interpret a constitution correctly or objectively. I mean, the idea of looking at state policy considerations, in my view, it's a little weird when trying to figure out what a constitution means. You ask what do modern statutes say? Would this be a good idea for Pennsylvanians or Washingtonians today? It's a weird thing to ask when the question is, what does our Constitution mean?
I think that's all true. I think there was, say, pre-incorporation, there was a lot of state constitutional law in, say, a lot of states, but I think how courts thought about the Constitution back then maybe was a bit different. And there is, like, I found where I've litigated the most on these issues is Minnesota. Minnesota has a lot of cases from, say, the early 20th century that are state constitutional decisions, but they're very focused on like a narrow number of provisions in what was a long constitution. Still is a long, well, any state is longer than the US Constitution. And, was that just that's where the action was? Was it that's where the regulations were? Um, I'm not sure. I think some of it today is, we have there's more lawyers, there's more the legal industrial complex is bigger, and they're able to come up with more ideas about what to litigate. But they're also, on the other side, the administrative state that we have today allows for a lot more worthwhile targets. I emphasize worthwhile to litigate about, because the government does a lot more, and kind of that all just means there's a lot more of this going on without a lot of the guideposts, because the guideposts were narrow and sparse.
Yeah, I mean, I think one reason for early 20th century lawyers to invoke a lot more federal clauses or state clauses that are sort of analogs to federal clauses is that the analysis might be more familiar. It might be just easier to understand how you would brief it at all, rather than invoking some never litigated and unique part of your state constitution that you then have to come forward to the court with a theory of what this even means. That's kind of scary if you're not a lawyer who really specializes in that.
Although that's a good point, and that kind of runs against my original assertion, right? That is that incorporation made it a whole new ball game, and we're still dealing with that. I mean, that did it. You would see cases from the early 20th century about a state due process clause where they're citing all these cases from the federal Supreme Court about due process, which to some extent maybe is what we now call lockstepping, but it's also, I think, kind of the idea of the general law back then, and the pre-Erie world where, the law wasn't state bound. And to some extent, I think that bled into thinking about constitutional law as not bound by a particular constitution.
Not everybody knows what Erie is, Anthony.
Yeah. And I don't even know if we're going to explain it right now, but never mind Erie. But yeah, the world back then, judges thought more just about kind of a general law, and this usually was a common law thing. And there's some really interesting scholarship that I haven't, tell the truth, read all the way through the last year or two about this, how to think about the general law that's shining new light, I think, on like the 14th Amendment, that people can go check out. But I think the idea of the general law was infused with the constitutional law more than we give it credit for. I don't know if that changes a lot about how we think about the Constitution, but in some ways it was kind of a pre-positivist era where we actually don't worry as much about the text of the Constitution to some degree. And that I guess I don't know if that has a lot to do with what we're talking, how we're litigating today or not, if we have to worry about that. But it maybe informs some of those older precedents too.
I mean, I think one thing that I have thought about arguing in cases that I've tried to develop that I haven't quite got off the ground yet, but there are jurisdictions where I'd like to bring certain types of state constitutional claims where when I looked at the precedent on that claim, it was very obvious that the relevant cases were all decided during a period when that state's Supreme Court didn't really have a handle on independent state constitutional interpretation, didn't really recognize that it was a thing. And so part of my thought was, well, I'm not really worried about litigating in this state because ultimately we might be one of the first plaintiffs to come in and say, hey, you've started to recognize this is a thing only in the last decade. And so all these older cases talking about this provision, they were decided before you recognize your independent role as the interpreter of your state constitution.
Yeah.
And so it's time to do that work.
That's good.
So the Supreme Court has not given us a lot of grist to use this term because I think it only has one published opinion so far, but it is an interesting one. And this is Acheson Hotels. We're not going to talk about the ins and outs of everything to do with it, but this is the case people remember where there was a woman who was suing a lot of hotels all over the country for Americans with Disabilities Act violations. created her own circuit split.
Can you imagine creating your own circuit split? The 2nd, 5th, and 10th Circuit all said that she didn't have standing, and the 1st, 4th, and 11th Circuits all said yes. So, like, this case was going to go up with Deborah Laufer as a party either way, which is just bananas. But I'm sorry.
Well, you explained it too. And then the Supreme Court finally takes one of these where they said that the lower court said she did have standing. Then she tries to get rid of the case by dismissing it because the writing was on the wall about losing.
Well, that's not why she dismissed it. There was like an enormous amount of scandal with her lawyer.
The court said. So,
well, okay.
we can talk about that or talk about other things the court did. But that's basically, the Supreme Court said, well, maybe she dismissed the case and it's fairly obvious. I think if you read between the lines, all the justices agree. It's fairly obvious she did this because she doesn't want to lose and she thinks she will. But her attorney is kind of a sleazebag and is in trouble. And that's why she's saying she wants out. So we'll give her the benefit of doubt this time.
So can I clarify for listeners just to kind of put a finer point on what the standing issue is in the case. So she's a self-described ADA tester. And the Americans with Disabilities Act requires hotels and other entities to provide information online about whether they have like handicapped and disabled accessible facilities. And so her position is she is injured by the failure of a hotel to post that information online, regardless of whether she ever intends to visit that hotel. Her position is, I'm injured by virtue of the fact that you haven't said it on your website. And so her practice was to sue, and she brought hundreds of lawsuits all over the country, basically asking for a court to enjoin the hotel to force them to post that information, and also seeking, as it happened every single time, $10,000 in attorney's fees in all these cases. So anyway, that's the issue. That's kind of the factual context for the standing question that the court is asked to resolve in this case.
And it's not, for those non-lawyers who don't know this area, that probably sounds kind of wild, but there is precedent, say, in this area. So like testers for housing, where you will send for an open room in a rental, you'll send a white person to go say, do you have any, can I live there? And they'll say, sure. And you'll send a black person and they'll say no. And then that's evidence for a violation of the Fair Housing Act, right? And the court has said you can do that, even if the black person had no intent to live there. So, and now does it go to this context, where it's just a website? Who knows? But that would been the ultimate question for the Supreme Court.
Yeah, and so I can tee up. Let me tell you what happened, and then we can kind of talk about some of the issues that raises and some of the concurrences. So to make a long story short, as listeners probably know, standing is something you need to bring a lawsuit in federal court. It's a requirement of Article 3 of the Constitution. Courts can only decide cases or controversies, right? And so what the court has said to kind of execute that is that you've got to have an injury, you've got to have causation, you've got to have redressability. Basically, a court has to be able to solve the problem that you have, right? You've got to have a concrete harm that a court can remedy. And so the issue that kind of puts a wrinkle to this question when it's before the Supreme Court is that because she has dismissed the case in the trial court, there's a question of whether the case is now moot. And so standing goes to whether you can bring the case in the first place. And mootness goes to whether the case is now stale, right? You no longer have a live injury or controversy. And so they're kind of analytically distinct, but very related questions. And so Justice Barrett, writing for the majority, says, we don't have to address the standing question on which we granted review because the case is now moot. And everybody agrees that it's moot. And so that's how she resolves the case. And she, in her opinion, and the majority does, vacates the decision below.
Not everyone agrees it's moot. Justice Thomas certainly.
That's right. That's right. And we should get into that in a second because I think his opinion his concurrence is interesting. But just to wrap up the majority, so they vacate the lower court's decision under a doctrine called Munsingware, which effectively stands for the idea that if the prevailing party below causes the case to become moot, then for fairness reasons, we're going to vacate the lower court decision.
Yeah. And so Justice Thomas writes separately to say, look, I don't think that this. I don't think we need to talk about mootness. I think we need to talk about standing at the beginning, because this woman never had standing, and we shouldn't be mooting the case. We should just reach the question presented, which is a question about standing. That's the original question you have to ask in all of these cases anyway. Which is, it's an interesting concurrence, I thought.
Well, his concern seems to be that you would incentivize this kind of shenanigan if you didn't decide the issue. It's an issue on which there's an acknowledged circuit split. The circuit split's still going to be out there if the court doesn't resolve it, as it doesn't. And so this issue is going to come before the court again, right? And so Justice Thomas's position is, why would we wait when everybody even Laufer wanted this case cert to be granted in the case. Like, both parties wanted cert to be granted to resolve the split.
Yeah, I'm wondering what happened there. Like, why did she want cert to be granted when the current Supreme Court, they got to fix this? Not going to work out.
This was a hobby horse of hers, right? I mean, you could see why she would want the Supreme Court to weigh in on an issue that she's brought hundreds of cases about. But Justice Thomas, by the way, for what it's worth, I'll stake out a position on this. When cert was granted in this case, before some of the oddness started coming out and the case went awry, my view was that the Havens Realty case, Anthony, that you were talking about earlier about discrimination in housing, was actually distinguishable because the law there did give the public, or I guess the applicant for the housing, a right to that information. And it doesn't seem like the ADA, at least under my read of it as described by the courts. I haven't actually looked at the text of the ADA myself, but as the courts describe it, it sounded to me like the ADA didn't give you a right to information. What it gave you, or what it imposed, was a duty on the hotels to, post that information, but for the purpose of facilitating you accessing the hotel. And so Justice Thomas's point is, if you have no intention to go to the hotel, the purpose of this regulatory system isn't being furthered by requiring them to post it for you.
And the only thing that private litigants are entitled to are injunctive relief and attorney's fees. The Attorney General can go in and get damages and assess penalties and all of that, but ostensibly private litigants can't get money unless they're tied to the attorney and getting fees that way, which is deeply unethical.
So by the way, I just thought Justice Thomas's opinion was really, I don't know, just sort of, it struck me as his position was a little odd, right? So, he wants, I guess his position is, this is admittedly an advisory opinion if we're going to issue it, right? So he's like, I want the court to issue this advisory opinion on an issue of standing, and the whole point of standing is to prevent there being advisory opinions.
Well, how would it be advisory, though? It would just be saying this case is done because there's no standing.
That's a good point.
And that she couldn't bring these cases because she lacks standing unless she has the intention.
Well, I guess what would make it
advisory
is that it's moot, right? And so if there's nothing to, there's no threshold issue that needs resolving of whether the case could be litigated because the case can't be litigated.
Well, so that gets kind of to the metaphysical point that Justice Barrett kind of avoided, right? Which is it could be moot. It could be no standing. We can decide those in either order, she said, but we're going to do moot because it's kind of easier. But she didn't say they had to. And she says, if, in a future case, maybe ayabaya, maybe we do the other way. That's a Swedish thing that they say to their little kids when they're naughty, by the way, ayabaya. So they're not in a deep disagreement there. I think Justice Thomas was just yeah, I want to go the other way because this is wrong.
No, well, ultimately, the way I read, it's probably wrong to read motivations into it, but ultimately the way I read his concurrence and what it's trying to do is, if the point of enforcing the standing requirement is to prevent courts from issuing advisory opinions in totally abstract supposed controversies, then let's do one here to avoid a bunch of future advisory opinions, right? Let's do it now so that there's not a bunch of this later. Is kind of the way that I read it. An advisory opinion in service of not allowing more advisory opinions.
It's advisory opinions all the way down.
I just don't know that it's an advisory opinion. Yeah,
Yeah.
I don't know. I don't know that it's an advisory opinion. If you're saying that a litigant doesn't have standing to bring the case, I don't, like the temporal question, did you have standing when you filed the case? Do you have standing today? Mootness is a question of that. There are certainly mootness exceptions to standing requirements generally, most famously with abortion and elections. But I don't know. It just...
So the question they didn't get to that maybe just no one really pressed and has kind of been like, it's something we've had to deal with at IJ and a few times when we've thought about or had cases that go up or like we're amici in cases, is that if you are the respondent and or either side, actually, especially if you're the petitioner from the Court of Appeals or a state Supreme Court, and you're going to the Supreme Court and you're there, then your loss below itself is some kind of injury. So if the Supreme Court then says, this is moot, you still have this judgment below, this ruling. I mean, maybe it's technically not a judgment, it's a ruling. So how the court can say that didn't happen here is it vacated the lower. So for non-lawyers, vacate means it makes the win that Laufer had below like it never happened. It's non-precedential at best. And so
it's a nullity. That's what vacatur technically creates, a nullity.
Now, if they hadn't vacated it, I would be, and I was Acheson Hotel, I'd be super angry because now there's this precedent on the books that says I will lose in the future. I've been fighting in this case to rectify that. And I think under current doctrine, that still could happen. It's just, it makes it a little better for them, probably a lot better for them to have this vacatur. But I would say even with vacatur, it's still an opinion that's out there that was not overturned. It was, it's just like, it's not precedential. But courts can still,
but it shouldn't exist at all.
Courts cite the vacated opinions all the time, like in other jurisdictions.
It's published.
They're not supposed to.
It's published.
And so, like, it's out there. It's on the internet.
Everything's on the internet. Once you put something on the internet, it's there forever.
That, but it's a lot less harmful on the internet if you can say that case was overturned by the U.S. Supreme Court. And so that seems to me gives you standing to keep litigating the case. Not Laufer having standing. It doesn't matter at that point. It's Acheson Hotels having standing to continue the case.
Justice Jackson disagrees with that, Anthony. I thought her concurrence was... I thought her concurrence was really interesting, and honestly, I don't know what I think of it. Other than
I thought it was really interesting.
I actually think she says a lot without saying a lot.
Because I don't think she concludes that vacatur is necessary,
no.
or expressly not necessary. I think she's saying that we need to actually have a conversation about whether it's appropriate in a given circumstance, rather than just automatically shooting from the hip. And once something's moot, we just vacate and remand, and it's gone.
Yeah, I mean I thought her view of her opinion was precedent or the issuance of a decision that kind of moves the common law forward, at least in her use of that term. It's sort of like the development of the law forward. That's not an injury. And in fact, it's something to which the public is entitled. And I thought that was that was a little bizarre to me, because what do you mean the public is entitled to this opinion, staying on the books? Like, isn't the whole point of standing that the public is actually not entitled to advisory opinions? I just thought there were some things in her concurrence that struck me as quite odd, but she does seem, and I think this makes sense, against the idea of reflexively vacating lower court decisions.
So I've been in the circumstance of asking courts to vacate lower court decisions, and I've been in the circumstance of fighting a request from the other side to vacate lower court's decisions. And I think Justice Jackson gets it completely right when she talks about it as this equitable concern, and that courts need to separate the issues of mootness and vacatur to think about them separately, because that's just how they are. Like, vacatur is supposed to be rooted in fairness. You're supposed to consider the need for it in terms of the harms that it would avert. And so, when one side that won below is now doing kind of hinky stuff to get it to prevent that judgment from being reviewed above, then perhaps vacatur is necessary. And vice versa. If the party below is the one responsible for the reason that it can't go up, then maybe vacator is less necessary. And I know I've switched between vacatur and vacator. It's Latin, and it's like it's the whole thing with like, do you pronounce it Cicero or do you pronounce it Cicero? One is technically correct with Latin pronunciation, but it sounds bananas, so you don't actually say it.
This is why Sam Gedge needs to be on every Unpublished Opinions episode.
Well, there we go. But anyway, so like it's just
en banc wrong,
vacating. He says en banc. Blech.
Actually, there's no correct pronunciation for that.
Well, there's my version. So anyway, I just vacating is sometimes appropriate and sometimes not, and I think that's what the case law is pretty clear about, and that trying to allot not blame but perhaps responsibility for why the decision is no longer able to be reviewed is an important consideration in whether you eliminate that decision and you make it a nullity, whether it actually exists as a nullity or whether it's a thing that can be cited or
not.
I
don't understand actually how she comes out. And I'll read you one line from her concurrence that I think captures what I'm confused about. So she says, here's a quote. As a general matter, I believe that a party who claims equitable entitlement to vacator must explain what harm, other than having to accept the law as the lower court stated it, flows from the inability to appeal the lower court decision, unquote. I mean, I agree with Anthony that the decision is an injury, right? Like, why would you have to identify a harm other than the decision that is adverse to you? That just strikes me as weird.
Well, the harm, if it's a published opinion and you do business in that jurisdiction, it's a harm in a way that, we like a one-off, say, accident case isn't. I mean, it's much more than that.
Yeah, her view is, it just strikes me as a little counterintuitive because her position seems to be, if you're the losing party below, like that's not an injury to you, but it is an injury to the public if we vacate this decision, who were never parties to the case. Like that just strikes me as pretty counterintuitive.
Public so if you do vacate, can the public sue the Supreme Court in original jurisdiction for
I don't know.
vacating this lovely precedent they have?
Yeah, I agree with her the thrust of her opinion, which is we shouldn't reflexively vacate. But I don't agree with some of what she says about why it wouldn't be appropriate to vacate.
Well, some of that, though, also just goes to published versus unpublished opinions. Because if we live in this world where courts can choose what is precedent and what's not from stuff that they've already said, then it's kind of silly. But if there wasn't that distinction, then the only way they really could, I think, get rid of that precedent is to overturn it by taking the actual case.
But if you can't, you're left with a situation where the case still exists and it shouldn't still exist. And I think,
I guess I'd say if a party wants to continue it have to be the right side of the V, then by definition, it's not moot.
Well, but so what do you, what is Deborah Laufer supposed to do here? She's just supposed to, she's forced to continue litigating despite her.
Yeah, people are forced to continue litigating cases all the time.
Well, she brought the case, right? And so she put the other side out pretty hard by suing them, by forcing them to spend money briefing to the Supreme Court through argument. It just feels kind of inequitable to pull the rug out at that point.
Yes, and I'm not terribly sympathetic toward her travails through the courts of appeal and the federal courts across the country. But I don't know. It's if you are the plaintiff or if you are the appellant, when you are the one controlling kind of that part of the case, you should be able, I think, to stop that part of the case at a certain point. And maybe the limitation on that is when there's a harm to the other side and they want to keep going, then you're forced to keep going.
Yeah, I think if you sue somebody and then you go through discovery and that's expensive and they're defending against the suit, that's just part of being, a private party in the United States of America. Like there's a court system, people sue people. But once you've got like a precedential decision that adopts a rule that hurts you, it feels like at that point saying, never mind, this is all going to go away, but I get to keep the rule is a sketchy outcome. And that's the whole point of Munsingware, right?
Yeah. And look, and circling back to Justice Jackson's point, like, I think she's absolutely correct that it just shouldn't be reflexive.
Yeah.
Like, there, based on this conversation, there are perhaps times when it's appropriate, perhaps there's times when it's not. And so you just, rather than just saying every time, all right, it's vacated, you're done, say, okay, would you like to continue litigating, so that, as with Justice Thomas's opinion, maybe she just doesn't have standing, and you reach the final point, and then these hotels don't have to deal with her anymore.
So last point, I don't remember the ins and outs of this like I did maybe a few years ago, but Munsingware is only a thing for appeals from, or certiorari, from the courts of appeals. From a state court, I guess the court doesn't have that power to vacate lower court. They overturn them.
Oh.
They don't vacate them. So if this was a case coming from a state court, I think then you could argue it'd be different, because there's not that remedy of vacator.
Although I will clarify for listeners that setting aside the issue of the U.S. Supreme Court vacating state court decisions, state courts themselves often follow the Munsingware doctrine. And so just to give a very quick example of this, there was a decision in Pennsylvania's Intermediate Appellate Court that came down that affected basically a property rights case. And to make a very, very long story short, the Intermediate Court adopted an interpretation of a local town's ordinance that was in favor of a property owner and against the city's interpretation. And the property owner won in the Court of Appeals, and then the town basically what you would call petitioning for cert to the Pennsylvania Supreme Court. And the Supreme Court granted the case. And at that point, the property owner sold his property and didn't want to pay his counsel to litigate the appeal, and was like, this is over for me. Don't even worry about this anymore. And the town said, look, this can't, and he filed a notice of mootness. And the reason we know about this is that IJ stepped in as amicus to defend at oral argument the decision below.
You might have done that, right, Josh?
That was me.
Yes.
And so anyway, the court says in its opinion that the case is not moot, and effectively applying a logic like the Munsingware case. It would be unfair to the city to deprive it of an opportunity to complete the appeal in a decision that adversely affected it.
And I should clarify, the U.S. Supreme Court can vacate as a kind of the decretal language at the end of the opinion, a ruling of a state Supreme Court, but it doesn't do it in the Munsingware sense, where this case is over, let's just get rid of it. So my point is that all these equitable considerations might play out differently if this case had been from state court.
Yeah.
Well, thank you all for staying with us. I think this has been the longest unpublished opinions so far, because we had so many darn unpublished opinions this time. We look forward to having you next time. When that might be, we'll figure it out. But it's been lovely for you to join us all this way. But until that next time, that's just like your unpublished opinion, man.
I'm gonna do like a gentleman, go and get some hops, get myself a gun, and shoot myself.